Ready to start.
Good evening, everyone, and thank you for joining us tonight for Assemblymember Seawright's virtual Town Hall Tuesday. We will begin in just a few moments. If you're watching live on Facebook, please feel free to write any of your questions in the chat. Questions can also be sent to our office by email at seawrightr@nyassembly.gov. Our office has received questions for tonight the past few days as well, and we will work to get all of the questions answered. For any questions that we do not answer live tonight, our office will work to get you an answer as soon as possible. Again, thank you so much for joining us, and we'll begin in just a few moments.
Good evening and welcome to all of you who are watching and listening to Town Hall Tuesday, a special community affairs program live streaming on Facebook Live. This is our 43rd edition of Town Hall Tuesday. I'm Assemblymember Rebecca Seawright, representing the Upper East Side, Yorkville, and Roosevelt Island, coming to you live from the state capitol in Albany, New York. Yesterday was International Women's Day. I was proud to co-sponsor a resolution commending International Women's Day at the state capitol. I'm also the sponsor of the Equal Rights Amendment to be added to our New York State Constitution. I welcome this opportunity tonight to share an update on our work in Albany. I was pleased to co-sponsor legislation in the Assembly that we passed to better support and protect our nursing homes residents. Throughout the COVID-19 pandemic, along with my colleagues, we have taken action to pass legislation to support New Yorkers' health and safety during these uncertain and challenging times. We trust nursing homes and long care facilities to take care of our loved ones for their treatment and care. During this pandemic, the unthinkable occurred. Residential facilities put profits over patient care. They discharged and transferred patients to facilities that lacked the care they needed. I was proud to co-sponsor the measures and to cast my vote for Assembly Bill 3397 to repeal Article 30D of the Public Health Law. Repealing 30D, also known as the Emergency or Disaster Treatment Protection Act, will enable us to hold facilities and their administrators accountable for harm to patients and residents. On Roosevelt Island at Kohler Long-Term Care Facility, we addressed alarming reports when they came to our office of mixing residential patients and new COVID-19 positive patients. We formed a coalition along with the Manhattan Borough President, Gail Brewer, with the patients at Kohler to get out their message that nursing home lives matter. We are holding administrators of these facilities accountable for any harm and damages occurred to vulnerable individuals. When nursing home operators put their bottom line ahead of patient care, vulnerable New Yorkers get hurt. I am proud to support this legislation to right this wrong and better protect residents. Tonight, we have a very special program lined up for you. We will hear from the experts and advocates for elder advocacy and planning. Arnold Lewis will be our first speaker this evening. He is the administrative coordinator for SAGE Vets, Services and Advocacy for Gay Elders. He will be followed by Ronald Fatula from Ronald Fatula and Associates on Estate Planning and Elder Law. Brenda Stewart-Luke, Office of the Taxpayer Advocate, will also be joining us. So now we will lead off with Arnold Lewis. Thank you for joining us, Mr. Lewis. He is the administrative coordinator for Sage Vets. He served in this position since October of 2019. Prior to that, he's been a part of the Sage staff since 2016. And during this time with Sage Vets, he has managed to do an extensive amount of research throughout New York City and New York State. As a member of Care Management Department as well as Sage Vets, he has managed to provide clients and participants with access to various and much needed resources and support throughout the state. He considers it an honor to represent Sage Vets at several virtual and in-person speaking engagements. And I am a big fan of Sage, Michael Adams, our National Executive Director. And so I just want to thank you, Mr. Lewis, for joining us this evening and ask you to say a few words.
Thank you, Assembly Member Seawright. It's an honor to be here. And thank you for having Sage Vets to your event tonight. Some of the services, I apologize for the background noise if you can hear that. I live near a very lively area. But some of the services we provide include VA benefits, eligibility evaluation, case management assistance, support groups for older LGBT veterans, and legal advice, counsel, and representation regarding discharge status upgrades, especially regarding discharges related to sexual orientation. One of the projects that we are very happy to share tonight is the latest edition of the Sage Vets newsletter. Please see the link in the chat to access the entire newsletter. One of the features is an article about Lewis Miller, a military veteran and one of the first to be approved for the Restoration of Honor Act. While serving in the Navy, Mr. Miller repeatedly received 4.0 performance evaluations and was nominated for Sailor of the Year by his commanding officers. Despite his outstanding service, a disgruntled sailor reported suspicions about Mr. Miller being gay. After subsequent investigation, he was discharged with an other than honorable discharge for homosexuality, engaged in or attempted to engage in homosexual acts. Mr. Miller reached out to us after hearing about the Restoration of Honor Act, and we helped him submit one of the first applications to the New York State Division of Veteran Services and had his honor restored by the state of New York. We are also working on finding him private legal representation to upgrade his discharge with the Department of Defense. When asked how Sage Vets and the Restoration of Honor Act has helped him, Mr. Miller stated, I felt haunted by the discharge every time it comes up. But going through this process and getting my discharge upgraded has helped me re-enter a social space that I have avoided for too long. Sage Vets was also instrumental recently in helping a transgender military veteran get her monthly veterans benefits increased from 10% to 70%. Aside from the legal assistance, Sage Vets also has a few excellent virtual programs coming up later this month. On March 18th at 6 p.m., we will be presenting a program with the Federal Trade Commission to raise awareness about COVID scams and what to do about them. And on March 31st at 6 p.m., Sage Vets with the National Association of Black Military Women will host a webinar for Women's History Month. Topics will include the recent end to the ban on transgender people in military. Another topic to be discussed is Sage Vets nominating New York State's first transgender veteran to be inducted into the state's Veterans Hall of Fame. For those who are interested in attending either of these events, or if you would like additional information about our services, please contact me at alewis@Sage USA or at 929-484-4178. Thank you again, Assembly Member Seawright, for having us at your event.
Well, thank you, Mr. Lewis. I appreciate you joining us this evening. I'm a big fan of Sage, and I think we give money in the state budget for Sage, and we need to do more for our senior citizens and more for our senior LGBT population, and I'm pleased to be the lead sponsor of an LGBT curriculum bill in the New York State Assembly. And so moving on, our next speaker is Ronald Fatula of Ronald Fatula and Associates. He is principal and founder of Fatula and Associates law firm, one of New York's top premier elder law firms for more than 30 years. He has been devoted to advising New Yorkers about their legal and financial challenges of aging. This firm is highly regarded for its contributions and expertise in estate planning and administration, Medicaid planning, special needs planning, wills and trusts, probate, guardianships, and estate and guardianship litigation. And as an attorney, I know how important it is, elder law, and these particular issues, especially for families with aging parents and for the aging population themselves. So this is a very important topic. And Mr. Fatula, we welcome you this evening.
Thank you so much, Assemblywoman, and I appreciate it. I have so much information to go over. I'm going to share a PowerPoint if you don't mind. Okay, hold on one second. Can everyone see that? Probably not, right? Hold on. Okay, how's that? We're good?
All good.
Good.
Thank you, thank you. So yes, elder law is so important. As an elder law attorney, we handle all issues that involve seniors and I guess the over 55 community. Oops, let me just get the slides going. We have a lot of information that I want to present tonight. I have about 20 minutes, so I'm going to fly through some of these slides. If anyone would like these slides, feel free to email me if you'd like, or Jackie Rothermel. Jackie, you could put your email address in the chat box. We'd be happy to send the slides to you. First and foremost, when it comes to elder law, since it's multidisciplinary, you want to get your team together. It's not just the elder law attorney. You want your financial advisor, your CPA, and if there's a care issue, a geriatric care manager as well. So in advance, you do want to get your team together. You also want to make sure that you have your essential documents in place. Of course, you can only sign documents when you have the legal capacity to sign those documents. So you want to sign these documents well in advance, obviously, of needing them. So the 5 most important documents that every senior should have, and dare I say, everyone should have, every adult should have a last will and testament, a power of attorney for planning purposes, especially if you're over 55, a healthcare proxy, which you could simply download from the New York State Department of Health website, a living will, and for many, those that have assets and would like to protect those assets, either for estate tax planning to avoid probate, or even to do Medicaid planning, a living trust is quite important. Just briefly, a last will and testament is a document that sets forth where your assets go when you pass away. You can name anyone that you want, and you could cut out anyone that you want. The only individual that will get would be a spouse. A spouse has a right of election and is entitled to the greater of $50,000 or 1/3 of your estate at the time of death. Lots of people talk to me about will contests. They call us after the fact. I do want you to know that you can't just sue an estate if you're not named in it just because you think you should be named. So who could actually contest a will? Not everyone could contest a certain will. You have to be what we call a distributee, someone that would have gotten if there was no will. So for example, if there's no will and there's no beneficiary designation on an asset, New York State has a law, the Estates, Powers, and Trust Law, which actually sets forth who the beneficiaries are. And those are spouse and children, parents, siblings, nieces and nephews, etc. So whoever would get if there were no will, those are the individuals that have a right to contest. So always a spouse and or children can contest a will. And you can only contest based on these grounds. There are ways to avoid a will contest. Number one, a trust is a great way to help avoid a will contest, but there are other mechanisms that we can use. And one is to have extra witnesses to the will. We could actually put an inter rorem clause in the will, which makes it more difficult for someone who's getting something under that will to contest, because if they lose the contest, they lose everything. So there are a lot of techniques that we use. These are just a couple, but just know that there are ways to avoid a will contest. Nothing is foolproof, but we can lessen the chance. You also would want a special estate planning power of attorney. This is a power of attorney that actually lets the agent step into your shoes and handle financial matters, not just writing checks. But if we put in the right provisions, that individual can actually sign a trust, amend a trust, even revoke a trust that may not be good for you any longer. So we have to add these extra provisions into that power of attorney, especially for seniors. If you want to have a power of attorney, just let's say to have an agent do a closing for you, that's a very simple power, and you don't need an elder law attorney to draft that. But if this is going to be a planning power of attorney, if you're over 55 and you want your agent, who might be a child, might be a brother or sister, to step into your shoes and do the planning, or even tweak the planning that you've done, because there's always something to tweak later on in the event of incapacity. Someone that you trust, that you cherry pick, can step into your shoes and do the financial planning. In our typical powers of attorneys, we might add anywhere from 25 to maybe 50 provisions. The power of attorney law, there's a new power of attorney law that will come into effect on June 13th. However, any power of attorney that we do right now will be effective. And you don't want to try to beat the clock. God forbid if we're dealing with somebody that has the onset of dementia or is in the early stages of Alzheimer's, you don't want to wait to June 13th to do that power of attorney. Get it done right now. But that new power of attorney law actually simplifies the power of attorney process. We now, if we want to provide for some gifting, have the power of attorney with a separate rider that enables us to make larger gifts. And you need that to fund a trust. Well, in the June 13th, with that new June 13th power of attorney, we will not have a separate rider. All of those provisions will go into the power of attorney itself. And there are many other safeguards. So thank you so much, Assemblywoman, because I know that you supported that, and we appreciate that. Healthcare proxy is very simple. You don't need a lawyer to sign it. It's quite simple. You could download the form, but it's very powerful, because if you can't make your own healthcare decisions, again, you can handpick an individual and a successor individual to make those healthcare decisions. It is so simple to sign. You only need 2 witnesses. You don't need a notary, and the form is self-explanatory. And if you do need an explanation, the law provides for an explanation. So when you download the form, you are going to get the instructions on how to sign it. It is extremely powerful, and it does provide for for you to not provide what your healthcare wishes are, but the healthcare proxy form is a form in which you actually name someone else. It's an appointing document where you name someone else to make your healthcare decisions. A living will, as opposed to a healthcare proxy, a living will is where you put down what your healthcare wishes are, but the healthcare proxy will appoint someone to make your decisions. You could also make organ donations with that healthcare proxy. A living trust is the gold standard in which you can protect assets from Medicaid planning, you could avoid probate, you can actually avoid Medicaid recovery, and you could lessen estate taxes with the right type of living trust. There are many different types of trusts. A trust could be set up if there's a beneficiary that is disabled, and you want to create a special needs or supplemental needs trust. Well, that's what that's for. It's in the general obligations law. There's a law for that. If you want to provide for a child that may be a little reckless with money, and you want to protect those assets for that child, well, you could provide for that child, not outright, but in a trust where the assets, let's say when you pass away, the assets will be held in a trust for the benefit of that individual, and the money will be doled out over time. Again, for Medicaid planning purposes, a home, for example, a co-op or condo can be put into a certain type of Medicaid asset protection trust. And to protect that home, you want to make sure that home is protected for your family and possibly for yourself. For example, we talk about the Medicaid home care program, which is radically changing, but the change, at least for now, is temporarily been pushed back to July 1. All of these documents can be signed virtually, every last one of them. The governor has signed executive orders for virtual notarization, that's on this slide, and virtual witnessing, and these executive orders have been extended through March 28th. I know not long. We hope that they will be continued to be extended. And I know that there is a bill pending to make virtual notarization and witnessing permanent, but I know that there are some issues with that bill, and we'll see how that shapes up in the future. When we talk about estate planning, we do talk about planning for long-term care. So we want to make sure that you have a plan for long-term care, because long-term care is expensive and your Medicare doesn't cover it, your supplemental policy doesn't cover it, your Part D doesn't cover it, that's prescription drug policy. So you need to plan for it. So how do you plan? Well, if you're wealthy enough, then hopefully you'll have enough money to pay for this privately, but most of my clients don't. The middle class simply will not have enough money to pay for chronic long-term care. Home care could cost through an agency $30, $35 an hour. Nursing homes, private pay could be anywhere from $14,000, $15,000 to $30,000 a month. So you could pay for it privately. Medicare won't cover it. We may want to look at long-term care insurance. Veterans benefits have been watered down as of October 2018 for the aid and attendance program, we now have a 3-year look back. So many individuals look to the Medicaid program. And one thing that you should know, I know my time is very limited, but we have a very good Medicaid home care program in New York State, and we have a very good Medicaid chronic care in a nursing home program. Federal law provides that there's a 5-year look back when you apply for Medicaid nursing home benefits, and where Medicaid would look to see if there are any asset transfers or gifts, because again, Medicaid eligibility is based on your assets and your income. So if you made gifts to get down to a certain asset level, currently $15,900, then Medicaid will penalize you if you made those gifts during the prior 5-year period. Medicaid home care now has a 30-month look back. However, that has not, the new law was signed into law, but has not been, it will not come into effect until at least July 1. It was supposed to be effective as of April 1, but now for Medicaid applications submitted starting on or after July 1, or this might even be pushed out if there is still in effect the public health emergency as a result of the pandemic. I can't go into the details on the new law because there's not enough time, but the new home care law, whenever it comes into effect, basically tightens up Medicaid requirements, how you're eligible, who's going to prescribe the home care for you. It currently is your treating physician, but that's going to change. There will be an independent assessor to replace the current system. And if you have lots of hours through Medicaid, there'll be an extra review to see if you can remain safely in the community. We use irrevocable trusts to preserve assets, and there's so many advantages to the trust. You can see this slide later on. Do I have just a couple of minutes to talk about the Secure Act?
Yes.
Okay, thank you. The Secure Act, and now we might be looking at federal legislation which will actually provide for a Secure Act too, in essence, which will actually make it much easier for individuals to protect their assets for retirement. But the Secure Act was signed by President Trump in December of 2019, was effective about a year ago, and there are lots of good things that this law does. It removes the maximum age limits on IRA contributions. So as long as you're working, you could still make contributions to IRAs. And I dealt with a client last week who was 90 years old, still working. He looks great. I wish all of my clients were like that, but he's contributing to his IRA, and that's wonderful. You can make penalty-free withdrawals for the birth or adoption of a child, and withdrawals up to $10,000 from 529 plans, the education savings plans, to reduce student loans. And here, there are some more advantages. A biggie is raising the required beginning date when you have to start to take distributions from your retirement account up to age 72 from 70 and a half. And if the new law that's new federal, it's not a law, it's a proposal, gets passed, they will raise that age 72 limit even to age 75. And that is huge, because when you look at the statistics, when you can have money grow tax deferred, you can save more for retirement. And we all want to retire and be secure financially. Okay, I don't have a lot of time, but but you can have these slides. There are some great advantages, but there are some big disadvantages. So let me go over some of these disadvantages. And the biggie is that if you provide for your children, the old law was that your children can take over their life expectancies, and any third party can take over their life expectancy. It doesn't have, did not have to be a child. So the old law provided that if I have an IRA and I say that my 2 sons would be the beneficiaries, they could, when I pass away, take over their life expectancy. So maybe for over whatever their life expectancy is, could be, for my kids, about 50 years. Could you imagine how much money can, that whatever I would give them could grow tax deferred? They do have to take distributions every year, but it's based on their life expectancy. So my kids are about 35 years old, and that's a small number. The new law provides for a 10-year rule. So if you have children and you provide for their children, they would have to take over 10 years. They don't have to take every year. They could take everything right before the end of that 10th year, but we don't get this stretch, the IRA stretch over your beneficiary's lifetime, except, now if you look at this slide tells you who the exception beneficiaries are. A surviving spouse, she can take over her full life expectancy, like always. If you have a disabled child or a chronically ill child or any individual, that's an exception. They could take over their life expectancy. If you have a minor child, that minor child doesn't have to take any distributions until the age of majority, 18, and then has to take over the next 10 years. And if your beneficiary is no more than 10 years younger than you, for example, let's say you name a brother or sister, then that individual could take over his or her life expectancy. Here's the definition of disabled individual, okay? Same as Social Security Disability, SSD. Definition of chronically ill, same as your long-term care insurance policy if you have one. You know, how do you make that policy kick in? This is a great chart that just shows you very simply what happens. The required beginning date is when you have to start to take your distributions under an IRA. This chart tells you that if you die before the required beginning date, what happens to the exception beneficiaries, who are called eligible designated beneficiaries? They could always take over their life expectancies. But if you name individuals who are not within those exceptions, they're stuck with taking out over 10 years, no longer over their lifetime, okay? Designated beneficiaries are beneficiaries that are named, for example, in your IRA. You designated them. For non-designated beneficiaries, you don't have anyone designated on your IRA, and you die before age 72, the required beginning date, they have to take out over 5 years. But if you don't name anyone, they have to take out over your life expectancy. So if it's me, it would be my life expectancy when I die. We call that the ghost rule because I'm not here, but my beneficiaries take over my lifetime. So I tried to cram as much as I could into that short period of time, but if there is time for questions, I am more than happy to answer them. Okay, and thank you.
Thank you
so much. I appreciate the opportunity.
Thank you, Ronald. And we do have a few questions that have come in.
Sure.
A child lives with a parent. The parent recently went into a nursing home and became Medicaid eligible. And the child had cared for the parent for years at home. The parent recently died. Does the child have any rights to this home, or since the person had been on temporary Medicaid, does the nursing home get the house? This is a question that's come in from a constituent.
Okay, yes, no, it's a very good question, and it's a very complicated answer. The answer is it really depends. If the individual is in a nursing home and the value of the home was under $906,000, because that's an equity limit, the individual was probably in the nursing home and signed an intent to return back home. Medicaid in that case likely, not in all instances, put a lien on that home. If they did, we would try to see if we could negotiate with Medicaid if you're a child living in that home, or if we can't, Medicaid could exercise that lien, and when that home is sold, Medicaid will be paid back for what they paid. But it really depends. The facts could go many different ways depending on what the circumstances are.
And if the parent were still living, would something like a ladybird deed be effective? And can you describe the ladybird deed?
Well, you know, it's interesting. We don't have ladybird deeds exactly in New York. It's more of a Florida thing. But we do have life estates. You know, if the home was transferred subject to a life estate, then the home is out of the individual's name for Medicaid purposes, but the individual would have a right to live there.
Okay, I think the ladybird deed was invented by LBJ, Lyndon Johnson, for ladybird.
That's right.
We have a veteran that has written in. What about VA? If you are a veteran with service connected 100%, how can I find out what I can get medically if needed? Okay.
Well, you know, the VA is really terrific. Yes, the aid and attendance program has been watered down a bit, but if you have 100% service-connected disability, you can actually go to a VA nursing home, and the nursing home should be free to you, depending on availability. So we have so many clients, you know, where the parent or the spouse or the individual is in a VA facility. They are getting great care, and the VA is paying for it. So with 100% service-related disability, that should be the case for you.
Okay, and we have another constituent that has written in, I need a personal representative. I need a personal representative as I have no one aging solo, and I don't have anyone to take care of my estate or my pets after my death.
Okay, so what you could do is, I mean, there's so many things that you can do. You could actually do all of your documents. You could even have a pet trust in your will, which provides, you know, for some money to someone else to take care of your pet. Or your, you know, your dog, your animal. I happen to be a vegan, you know, because of, you know, and I very much support these issues, and we do a lot of pet trusts. But you can name a trustee to take care of your pet. You could also do a living trust and name a trustee. And if you don't have a trustee, there are trust companies that could come in and act as a trustee and manage your assets and have them go any which way you want. And, or if you should become incapacitated, manage those assets for yourself. If you don't do that, of course, we could always go to court for a guardianship and have the court name a guardian. But you might as well be proactive if there's a good friend that you know who could act on your behalf. You could sign a power of attorney to that friend that you trust implicitly, a healthcare proxy, a living will, and they could help you if they are willing and able, if something should happen to you. If not, again, we could go for a guardianship, or you could do a trust, and a will with a trust in it, or a living trust, and we can provide what happens to those assets should you become incapacitated.
Okay, well, thank you very much. We appreciate your expertise on elder law with us this evening, sharing all your advice, and I trust we can reach out to you if more questions come in. And
Sure.
so, once again, we thank you for joining us this evening.
Anytime. Thank you so much.
Our next speaker is Brenda Stewart-Luke. She is a IRS veteran, Office of Taxpayer Advocate, and she's also joined by her colleague, Georgia A. Thomas, Area 4 Manager, Stakeholder Liaison for the IRS. Brenda has been with the IRS for 42 years, and during her tenure, she has worked in various business units of the Internal Revenue Service, such as criminal investigation, collection enforcement, taxpayer assistance manager, and New York acting area manager for stakeholder liaison. Brenda currently works as the senior stakeholder IRS communications liaison. As a stakeholder liaison, she participates, coordinates, and collaborates and shares IRS key messages through outreach. So we welcome her and her colleague, Georgia A. Thomas, this evening. And we welcome them to say a few opening remarks.
Yes, thank you so much. My name is Brenda Stewart-Luke. Thank you so much, Assembly Member, for inviting us to speak again. And we welcome information that was shared today. It was very much appreciated. But before I go on to give my PowerPoint presentation, I'd like to introduce my manager, Georgia Thomas. And Georgia will give you some opening remarks. Georgia?
All right. Thank you. Again, my name is Georgia Thomas, and I come to you from Houston, Texas. We are a part of Stakeholder Liaison, which is, as indicated by the Assemblywoman, a part of communications and liaison in the IRS. And we do outreach and education, much like what we're doing this evening, to various different stakeholders, practitioners to industry groups and others. And so we speak on a wide range of different topics. The area that we cover, Brenda and I, are Texas, the state of Florida, the state of Georgia, South and North Carolina, and then of course, New York. And so I rely heavily on Brenda for all things New York since I'm in Texas. And so again, it's a pleasure to be here, and thank you, Assemblywoman Seawright, for inviting us. And I'll act as Brenda's backup during today's presentation. Thank you.
Thank you. And where in Texas are you?
I'm in Houston.
Houston, my home state of Texas. All right. Well, thank you both for joining us this evening. And we have some questions that have come in from our viewers. How do I know if I qualify for the recovery rebate credit? Can you please identify the reasons why one may not be eligible for the recovery rebate credit?
Okay. One of the reasons why it could be that an individual were claimed on another person's tax return. So if an individual were claimed on someone's tax return, they would not be eligible. And this is some of the things that we're going to go over in our PowerPoint. I'm going to go over. It says, who is not eligible? Not eligible for the first or second round is non-resident aliens, estate and trust, individuals who could be claimed, as we previously stated, as a dependent on someone else's tax return. So this was, eligibility was considered based on, as it states, the 2019 and 2018 tax return. And we're talking about two different payments. The first round was referred to as the economic impact payment, and the second round, which came out as of December 27, was referred to as the recovery rebate credit. So there was different eligibilities, but basically it was the same. That's who would not be eligible. With this economic impact payment, some was made to people who died before receiving the payment. They should return this payment to the IRS. And if you go on our website, it would give you the address in which you would send that payment as well. So this recovery rebate credit may be claimed for individuals who died in 2020 or 2021 when filing the decedent's tax return. But afterwards, this return had to be, the money would have to, the payment would be returned to IRS. Next slide. Taxpayers with ITINs. Individuals that filing a tax return using an ITIN. An ITIN is an individual taxpayer identification number that is not a social. This is a number that IRS would give to an individual that is required to file a tax return. So individuals filing a tax return using ITIN did not receive the economic impact payment. They were not eligible to receive the recovery rebate credit, even if they had a qualifying child. Also, joint filers filing a tax return using two ITIN did not receive an economic impact payment. However, there were some changes that came about with the recovery rebate credit. Next slide. Also, joint filers who file a tax return using one social and one ITIN may have received this second economic impact payment, but they were not eligible for the first payment. The only person that was eligible with the ITIN, it would be persons that was in the U.S. Army, and if they had, or they were married to someone that actually had an ITIN. So joint filers filing a 2020 tax return using one social security number and one ITIN, they may claim a recovery rebate credit, the one spouse, because they have qualifying children and they have a qualifying number. So that was the difference between the economic impact payment and the recovery rebate credit. Next slide. However, we had the deadline for persons that was incarcerated. Previously, it was later on, persons that was incarcerated, they had to file a simple return, or the deadline was November 4th, 2020. So if they did not receive both the economic impact payment or the recovery rebate credit, they had to apply for this on this upcoming tax return on line 30 of their tax return. That's how they would go about getting this the payments. So individuals were not denied because of the fact that they were solely incarcerated, which a lot of people mistakenly thought. Next slide. Next slide. So the first impact payment will offset when individuals owe past due child support. So if a person owed child support previously in the first economic impact payment that came out as of March of last year, they were not entitled to the economic impact payment. However, the second economic impact payment, they were not offset. This was not applicable. So again, these were changes that was made. So there was a big difference between the economic impact payment again, and also the recovery rebate credit. Next slide. Taxpayers, you might ask, how were the second economic payment issued? Well, taxpayers that had direct deposit on file, which we had their information previously, that would have been through using our tool where they could upload the information through the Get Payment tool, or let's say they filed a tax return previously where we would have had their prior information. We utilize this information to send direct deposit to the banking account that they had on file. This would be individuals perhaps that had Social Security or veterans. We had their information already. Those without current direct deposit information on file, generally and often, they receive payments as a check or a debit card in the mail. But those individuals, as of now, that might not have received the economic impact payment or the recovery rebate credit, what they would do currently is once they file their 2020 tax return, that information could be input or provided on line 30 of their upcoming tax return for 2020 or either 2021. Next slide. Payments were issued automatically. Eligible persons that filed 2019 tax returns that were eligible, it was sent out right away. Eligible individuals who provided their information through the non-filer tool, which they had until November to actually go into including their information on that non-filer tool, which is currently not working. It's not in operation. And again, these individuals, these non-filers would be people typically that would not be required to file a tax return. But however, they had a valid social and they were an American citizen. So these individuals would have used this tool to update it with the information, and we would have automatically forward them a check. But again, currently, to be eligible for this, if they did not receive the full amount that they thought that they should have, and they did not, as we'll see, capture this information through a form or letter 1444 or 1444B, they would then go ahead and complete a required tax return, and this information would be included on line 30. Next slide. Approximately currently now 8 million payments have gone out for the second economic impact payment. And if the Get My Payment tool shows, it would show the date. If you go to irs.gov, we have information, we have a Get My Payment tool. It will show you the status, and it will show you when the economic impact payment or recovery payment was forwarded. So that way you would be able to watch in the mail for either a paper check or a direct debit card. And you could get additional information by going to www.eipcard.com. Next slide. Some payments were sent to temporary accounts that were closed. And IRS will reissue payments for taxpayers who did not receive the second economic impact payment because of the temporary bank accounts. But again, this information is again being captured on line 30. So the persons are going to have to find and file a tax return, and that way the information could be captured. If they feel, again, information might have been sent back, they did not get the response back about bank account was closed, they can actually go in to complete a tax return, and then they would be issued that money via how they would specify now. It would be either a check or either through a banking account. Next slide. As I discussed before, this first payment, they received the notice 1444, which was mailed 2 weeks afterwards, making the person aware that they received the payment and the amount of the payment. Now, the second recovery rebate credit, the persons were issued a letter. It would be a letter 1444B. And again, that was received 2 weeks after, making the person aware of the funds or the amount of money they would receive. So when a person now goes to have their return completed, they would provide these documentation to their tax provider or the person that's completing their return. So line 30 is going to ask, when you're preparing the return, did you receive the economic impact payment? But if you did not receive it, that is when you would provide that information. If you receive it and it was satisfied, you do not have to include anything. Next slide. Again, the economic impact payment it should not be included in the gross income. It is not taxable. Payments should not affect individuals' income or for the purpose of determining any type of eligibility they would receive from government assistance. So you do not need to pay this money back, which a lot of people thought. Next slide. The recovery rebate credit, this is the second. Anyone who received the amount for both economic impact payment, when they file their tax return, they would actually, there's nothing really they have to do if they got the full amount. Next slide. Again, who's eligible? And the best way to do this, and how can one claim the recovery rebate credit? Eligible individuals who did not receive the full amount, they would complete a tax return. And we suggest e-filing. This is the first year that you're able to amend your return or amended by usage of a 1040X that you can do electronically. So if you go ahead and file it through e-file and you know that you have to make a change, it will allow you actually to go ahead and make that change using electronic means. Next slide. Children born or adopted, these again, recovery rebate credit, these are ones that are eligible. This is, I think, was really great for individuals to be aware of. College students who were claimed as a dependent on their parents' tax return in 2018 and 2019. So now they become eligible themselves. Next slide. There is a worksheet that you can utilize in order to determine the amount that you receive, the actual amount that you would do. So this is something that is used through the various software that you might utilize. Next slide. And information that we have, you can go to irs.gov. You actually can develop your own account, or you have an online account which allows you as an individual to access information about your IRS account or your IRS dealings. So you can actually establish that. That way you would view your account online. Next slide. You would have to register, and if you go into our website, which talks about an account, it would give you the process in which you can actually go through setting it up. Next slide. You would be able to view your account, you register, it's actually friendly. That way, you can actually go in to find out, because some people forgot, it's been last year, how much they received. So using this tool, it will help to refresh your memory and also make sure that it's accurate what you're putting down. Next slide. As it said, you'll be able to view your accounts, the payments that you might have received, and actually look at the balance. So these are things that actually makes it a lot better. And since it's done electronically, it's not like you're waiting for someone to send you some documentation. Next slide. This talks about the Get Payment tool that we talked about previously, how you're able to track and look at your status of your payment. Next slide. We suggest, because a lot of people may have questions and answers, we have a frequently asked questions where questions that come up that we cannot answer or it's updated once a day that might have come into the IRS. We suggest going to our frequently asked questions, and we have questions and answers there, and it's updated once a day. Next slide. We also want to suggest, especially during this time period, that you want to watch out for various scams. You have various scams that people tell you they will help you to get your economic impact payment quicker. There's some scammers that use emails or phone calls or even texts to try to get information from you. We will not do that. We will not tell you or have other people there to help get this refund quicker. A lot of people are charging a lot of money. So what we suggest that you do is to write down how to report these scams. You would go to phishing@irs.gov, and IRS has official information. So you have to go through the IRS in order to get the economic impact payment. Next slide. We have the website, as we discussed here, about Get My Payment. It mirrors here this this photo mirrors what's actually on the website. Next slide. We have partners, we have promotional materials. We look forward to, just like we really appreciate the Assembly member actually having this event, we look to promote this information, making people aware of what they need to do in order to get the economic impact payment. So we have material there that's promotional that to help to get this information out to the communities. Next slide. And if there's any questions, you know, we're open to questions. And I just wanted to add also, one of the things that we wanted to make people aware of the fact that individuals that receive unemployment, they're going to have to go to the New York State Department of Labor's website to download the 1099-G because it's not being sent to them by mail. So it's important for them to go to get their 1099-G, not to prepare their return using their last pay stub. So I thank you so much. I hope this information was helpful and it answers several of your questions.
Well, thank you very much. And it was a very informative presentation. And so I thank you and your colleague, Ms. Thomas, for joining us this evening. And I know that many of the seniors in my district, they don't have access to the internet or a computer or the computer skills. And so there's many community-based organizations that pair up young people, high school students that need community service. So I want to encourage our viewers that need help with the internet or with some IRS forms to please call our office at 212-288-4607, and we will pair you up with a community-based organization or person that would like to volunteer. So again, I want to thank you both. And it looks like we're running short on time here, so I'm going to move into our closing remarks. We have heard the allegations against Governor Cuomo as the chair of the task force on women's issues for the New York State Assembly. I continue to steadfastly support the independent investigation of multiple allegations of sexual harassment by Governor Cuomo. The New York State Attorney General, Letitia James, is doing her job with customary diligence to ensure a fair and thorough process. We need a prompt investigation that follows all facts wherever they lead and a report to the public on its conclusions. So I'm advocating to let the Attorney General do her job. For COVID-19 updates, I ask that you please sign up for our weekly e-newsletter by emailing cwrite@nyassembly.gov. The New York City Department of Education will be reopening our high schools for in-person learning on Monday, March 22nd. Additionally, I want to ask that you join us for one of our upcoming events that I am pleased to sponsor on Tuesday, March 23rd at 7 p.m. on Facebook Live and Zoom. We'll be hosting our Women of Distinction Award ceremony. We're asking for people to nominate a woman for a distinction award in our community by Wednesday, March 10th, or call our office to submit your nomination. On Thursday, from 12 to 2, we'll be continuing our face mask and hand sanitizer giveaway at our community office on York Avenue between 78th and 79th Street. We've started our weekly knitting social back up by request. We ask that you join us on Thursday from 2 to 4 on Zoom to knit and chat with your neighbors. That's very popular among some of the knitters in the community. We have a no-cost free housing clinic with a pro bono housing attorney. On Tuesday, we ask that you sign up with our office. It does book out. The next clinic is on Tuesday, March 16th at 2 p.m. by telephone. We're hosting a homeowners benefits clinic with the New York City Department of Finance on Wednesday, March 10th from 2 to 3 p.m. And again, call our office to register and sign up. We ask that you stay connected with our office by signing up for our email blasts. Follow us on Facebook, Instagram, and Twitter at CWrite for New York, or again, call our office at 212-288-4607. And for now, stay safe, wash your hands frequently, keep your social distance, wear your face coverings, and please don't hesitate to reach out to our office if we may be of assistance. Thank you again for viewing this evening and to each of our speakers. Have a good night.